The Casual Workers Advice Office has condemned the Commission for Conciliation, Mediation and Arbitration findings on the dismissal of a cancer survivor. In April this year, Dis-Chem declared the role of its worker redundant and terminated on grounds of medical incapacity. Let's look now at what workers can expect from their employers if they are too sick to work. And I'm joined in studio by legal expert Kevin Smith. Kevin, a very good afternoon to you. Thanks very much for your time. I suppose, I mean, a point where we should start here is that, I mean, thanks to decades of struggle and of sacrifices that were made, you know, by many thousands and thousands of workers, South Africa or South African workers are in a better place today.
Correct.
Compared to, let's say, during apartheid.
Correct.
You know? And certainly in terms of the law.
Correct.
That's correct.
Yes, I think the Labour Relations Act in its entirety, that is exactly what it was meant to do. It was meant to transition us from a time when our migrant labour and the entirety of the labour in South Africa was for exploitative purposes and for exploitative purposes alone. So the Labour Relations Act came in to make sure that there's fairness in one applying their trade, there's fairness in companies actually making use of labour, and that the labour market is essentially there to make sure that our citizens can become self-sufficient, can become economically active. So it's a very great step that the Labour Relations Act in its entirety is actually brought into the South African labour market.
Of course, I mean, that's not to say all is hunky-dory.
Of course.
Workers will still win some, lose some of their cases. A lot can actually, and does, go wrong. In other instances, I'm not saying that is the case in this one, you do also have unscrupulous employers who do take advantage of workers or who simply do not care. Yes,
of course. And I think one thing we always have to understand as people who are within the labour market is that labour in itself is a form of exploitation that you get compensated for. Depending on that level of compensation, the level of exploitation then changes. So it's always essential for our labourers to understand what exactly is their value within not only the labour market as a whole, but within the employment relationship with the employer that they have. Because it's only with that understanding that you can use the Labour Relations Act to your advantage, where you can use the Basic Conditions of Employment Act to your advantage. It's first understanding your relationship to your employer and then understanding what the legal infrastructure then comes into play to protect you. Because we do have an extensive labour legislation that is actually there to take care of our labourers. So in instances where we do have unscrupulous employers, it's only because it's that the employees don't have full or sufficient understanding of the law that protects him. And the point I'm trying to make there is that our law doesn't have a lot of omissions that can be taken advantage of. The omissions that people take advantage of is omissions of understanding. So it's usually omissions of knowledge that lead to exploitation at large.
Let's take now the case of Refilwe Madingedza. Worked for Dis-Chem from March 2019 as a picker at its distribution center. She had to have cancer surgery in 2022. After this, she could no longer lift heavy items, obviously because she was sick. She had been fitted with a bag rather. She was given a temporary job as a checker, but was then later told that the position she had been given as a result of her sickness was redundant, and in April this year, she was dismissed. And that, in a nutshell, is what happened. I mean, here. Where do you think her case fell?
Look, first of all, I'm glad that you took us through the entirety of how this thing comes about, because that is essentially where we find either the case for Dis-Chem or the case exactly. It all happens when you look at what actually factually took place. It's not necessarily one where we just look at what the law says. We have to make a factual inquiry. So like you rightfully pointed out, she went into surgery. She was diagnosed with cancer. Certain health issues then came up. Now, what the Labour Relations Act, particularly says in these types of situations is that your employer has to try and accommodate your disability or your illness to the extent that is reasonable. By accommodating it, they have to make sure that either the conditions under which you work have to now alter, or they have to adequately place safeguards in place to make sure that you can still apply your trade. If you can't perform the same job that you were doing at the time, they have to find alternative work for you within the same company, or sometimes
softer landing. So
exactly, to make sure that to the extent that they understand your incapacity, they then have to accommodate that incapacity to the point where it then becomes impossible. And this is why I had said that it's actually very preferable that you first took us through the facts of the case, because we then have to look at what did Dis-Chem do to accommodate her incapacity. What did they do to give her that quote-unquote soft landing? Did they offer her alternative work? Did they make sure that to the extent that she is now medically incapacitated, does that in fact affect the entirety of her being able to apply a trade? Or can it then be moved into a situation where the stomach bag and her health issues are not impacted by the job she actually does?
Which is what they did.
Of course, and that's why the CCMA made the proclamation it did, because it had to look at two things. It first looks at procedural fairness. Did they follow proper procedure in getting to this decision? But in an instance like this, they look at what's called substantive fairness, and they weigh that a bit more. Substantive being, are the reasons for the dismissal adequate?
And the why?
Of course, but only once they have looked at what had happened and what had taken place for them to actually accommodate her after she had come back to work.
Mm-hmm. And then, and how much of the fact that this scam was, had its own difficulties, where it couldn't carry, the numbers of employees that it was able to. Did that weigh heavily, against against her?
Yeah, again, a very great thing that you've pointed out there, because in Dis-Chem making its argument, they were asked, were there alternative ways that you guys could have placed her elsewhere? Because at the time she did a lot of manual labor. Could you have been moved to a place where there isn't as much labor? Could you have been trained to then do an office job? And what they were saying is that the options that were available to them, there were already restructurings taking place, meaning that there were other employees in those sectors who were also being let go, and the reduction of the number of employees that they had in the sectors that could have accommodated her were also now being reduced. So it could have been a situation where certain employees would have been let go, and then she would then have to replace them, which would also then give them an alternative claim at the CCMA, where those who are let go are saying, I was let go, but someone was brought in my stead. Was it necessary in the circumstances? So they did bring forward in terms of the argument to show that initially what we did was we gave a soft landing, we gave retraining, we moved. But the other options of moving that were available, those were unfortunately in sectors that were also being reduced. So again, on the factual side of things, they had to convince the CCMA that those alternatives were not available to us.
Of course, could it be, and this is in the realm of speculation, could it be that, let's say, even if there may have been, or they could have opened like a little window of opportunity, say for her, let's say out of compassion, a possibility existed that they could then be challenged by those who would have lost their jobs in the place or places where she could be accommodated. I'm saying that possibility exists. I'm not saying it is.
Correct, and that's something that I think on her side they should have argued on her behalf. But one thing that I think actually came to a disadvantage is that she did say at the time of the dismissal that she was now fit to work. However, she didn't have a medical report to back what she was saying. So she couldn't substantiate that by showing that medically I've been cleared to do my normal job, or the extent of my incapacity has now been mitigated or reduced. I think had that been with her at the time, it would have strengthened the case, because it now puts Dis-Chem in a place to understand that the incapacity that she couldn't perform a job at a certain level has now been mitigated or is now no longer there. So which means that the option of placing her in a regional job is there. In the alternative fields, they are also there because she doesn't have the same incapacity issues that she once did have. So I think what weighed most there is the fact that she didn't have a backing medical report to show the extent that she now has healed or she can now apply a trade.
But now, if we were to talk about compassion, right, I then argue that, yes, strictly speaking, right, the events are as you have so eloquently described. However, what if someone had said, okay, can we then check, can we get a medical record that then shows, you know, whether in fact you are in a much better position now and can perhaps even perform the duties you once performed?
Yeah, correct.
Could that not have?
I agree with you wholeheartedly. And I think this is where I think the CCMA did not go as deeply as we may have wanted. Because in any situation where someone in South Africa, given the economic intricacies and the economic constraints that we have, anyone who loses their job for any reason is an injustice. But on those factual grounds, I don't think the CCMA had the necessary legislative authority to request for that to take place. Because again, they are constricted to things like the Labor Relations Act, your employment agreement, the Basic Conditions of Employment Act. They're restricted in those fields because, again, the CCMA is a specialized tribunal, but it's not a court. So they don't have necessarily the discretionary powers to make those types of proclamations. So I do foresee if this is appealed and it goes to an arena like the Labor Court, which is even more specialized but has the powers of a high court, then those types of considerations may become something that weighs even more in her advantage. But like you rightfully pointed out, as a point of not just compassion but loyalty of her service, were all of the necessary options and
Possible.
was everything, did they do everything possible? And we are not sure. They have said that they had given her extended sick leave. They had paid for that leave even before the applications were done so that she doesn't wait the 3-month period for that to kick in. They had done everything on their side that they felt was necessary. So should further considerations have been made, we'll have to see if a different body actually proclaims on that.
Kevin Smith, thank you very much for your time.